You've heard the story about the Greeks and the Trojan horse?
Who hasn't? The Greeks built a Trojan horse, left it outside Troy's city walls as a spoil of victory. Then soldiers hidden inside snuck out at night and opened the gates from within. Classic.
Solid movie. Great cast. In the Trojan horse story, the Greeks didn't arrive in Troy while they camped outside the city walls. The Greeks only arrived in Troy once they actually got inside the city.
Okay, where are you going with this?
That exact distinction, whether you arrive in a place by getting close to it or by actually entering it, that's the entire fight in a Supreme Court case about asylum seekers at the border.
Wait, seriously?
Seriously, between 2016 and 2021, immigration officers physically blocked asylum seekers from stepping across the border into the United States, told them to come back later, and whether that practice violated federal law turns on whether someone arrives in the United States while still standing in Mexico.
That's actually the legal question? The preposition?
The preposition, and that single word determines whether hundreds of thousands of asylum seekers can claim federal statutory protections. That's what the Supreme Court tackles in Noem versus Lado. The court hears oral arguments in this case on March 22nd, 2026.
Okay, before we dive in, I need you to picture this. You're a border officer standing at a port of entry. Someone approaches from Mexico seeking asylum. They literally just need to take one more step to cross into the United States. One step. Do federal immigration laws apply to that person yet?
You'd think the answer would be obvious.
You would. But the Ninth Circuit and 15 federal judges who disagreed with the Ninth Circuit went to war over this question. 15 judges wrote or joined dissenting opinions.
15?
15. And what's more, the Obama administration, Trump administration, and the Biden administration all took the same position on this issue, which almost never happens on immigration. And yet the Ninth Circuit panel still ruled against the government. And now the Supreme Court has to figure out whether federal law requires immigration officers to process asylum claims from people standing in Mexico.
Welcome back to the High Court Report.
Today, we're previewing arguments in a case that could fundamentally change how the executive branch manages border surges.
Quick reminder, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get nearly daily rundown, and follow on YouTube to see shorts. Just search the High Court Report. All right, here's what you need to know.
This case asks whether non-citizens stopped by immigration officers on the Mexican side of the U.S.-Mexico border arrive in the United States within the meaning of two federal statutes.
Okay, break that down for me.
So Congress passed two key immigration statutes. Section 1158 of Title 8 says any non-citizen who arrives in the United States may apply for asylum. Section 1225 says non-citizens who arrive in the United States must get inspected by immigration officers. Both statutes use the exact same phrase, arrives in the United States.
And the whole fight turns on what arrives in actually means.
Exactly. The government argues arrives in the United States means physically crossing into U.S. territory. You arrive in America when you enter America. The asylum seekers argue arrives in the United States includes anyone who reaches a port of entry and presents themselves to an immigration officer, even if that officer blocks them from stepping across the borderline.
So the government's reading says geography controls, the asylum seekers' reading says presentation controls.
Right. And here's the actual statutory text. Section 1225 says, and I'm reading this verbatim, an alien present in the United States who has not been admitted or who arrives in the United States shall be deemed an applicant for admission. And then it says, applicants for admission shall be inspected by immigration officers.
Shall be inspected. That's mandatory language.
Exactly. Not maybe inspected, shall. But the government argues that mandatory duty only kicks in once someone arrives in the United States, which they say requires territorial entry. Let me paint the picture of what actually happened on the ground, because the numbers here get absolutely wild. In fiscal year 2016, ports of entry along the U.S.-Mexico border encountered more than 150,000 non-citizens seeking admission.
How does that compare to previous years?
That represented a 70% increase over fiscal year 2014. Just massive, sudden surge. And these ports simply couldn't handle the volume. Internal government documents show the Tucson Field Office, which covers ports along the Arizona-Mexico border, reached 231% of detention capacity.
Wait, 231%?
231%. The San Diego field office hit 155%. Officials literally ran out of space. At the Hidalgo port of entry in Texas, one CBP official sent desperate emails saying, "We got hit hard with arrivals yesterday. Now bed space not available. Help!" with the word help in all caps and an exclamation point.
That's not normal bureaucratic language.
No, and the conditions got dangerous. At the El Paso port of entry, officials tried providing up to 1,000 meals per day using only microwaves. Equipment designed for maybe reheating staff lunches, now feeding 1,000 people daily. At San Luis in Arizona, overcrowding created what internal documents called unsafe and unhealthy conditions. Some asylum seekers slept outside the port after going days without medical screening.
And this triggered the metering policy.
Right. In November 2016, during the Obama administration, DHS adopted metering. CBP officers would stand on the U.S. side of the border and physically stop non-citizens without valid travel documents from crossing into the United States. Officers told them to come back later when resources became available.
How did they actually implement this?
DHS gave individual ports flexibility to apply metering based on what worked operationally and whether conditions required it on any given day. Then in 2018, the Trump administration formalized the policy through official memoranda. The Secretary of Homeland Security authorized CBP to establish and operate physical access controls at the borderline based on availability of resources and holding capacity.
And then what happened?
The Biden administration rescinded those Trump-era memoranda in November 2021. But, and this matters for understanding why this case still exists, the government still argues it needs to preserve the legal authority to use metering again if future border surges demand it.
So in 2017, an immigrant rights organization called Otro, Lado and 13 asylum seekers sued the government in federal court in San Diego. They argued that metering violated two specific sections of the Immigration and Nationality Act. Section 1158 says non-citizens who arrive in the United States may apply for asylum. Section 1225 says non-citizens who arrive in the United States must get inspected by immigration officers. The plaintiffs claimed these statutes apply to anyone who reaches a port of entry and presents themselves to immigration officials, regardless of which side of the borderline they're standing on when officers block them.
The district court sided with the asylum seekers on a key motion to dismiss. The judge concluded that sections 1158 and 1225 apply to non-citizens in the process of arriving, even if they're stopped outside the United States. The court certified a class covering all non-citizens who sought or will seek to access the asylum process by presenting themselves at Class A ports of entry on the U.S.-Mexico border and got denied access by CBP officials on or after January 1st, 2016.
That's potentially a huge class.
Huge. The court then granted summary judgment to the plaintiffs and entered final judgment with both injunctive and declaratory relief. One part of the judgment individually named a plaintiff called Beatrice Doe and ordered the government to facilitate her entry into the United States and ensure her inspection and asylum processing upon arrival.
Wait, the court ordered the government to facilitate her entry?
Facilitate her entry. And that language becomes really important when we get to the government's arguments about what the Ninth Circuit's interpretation actually requires.
The case went up to the Ninth Circuit, and a divided panel initially affirmed the district court. Then something unusual happened. The court sua sponte, meaning on its own initiative, asked the parties to brief whether the case should get reheard by the full court sitting on banc.
That's the court basically saying, we think we might have gotten this wrong.
Or at least acknowledging serious concerns. After getting those briefs, the panel issued amended opinions. The majority rewrote a section on the presumption against extraterritoriality and made some other changes, but the bottom line stayed the same. The panel ruled for the asylum seekers.
What did the Ninth Circuit majority say?
The majority concluded that arrives in the United States includes non-citizens at the border, whichever side of the border they're standing on. The court reasoned that to arrive means to reach a destination, and for an asylum seeker, the relevant destination becomes the U.S. border, where they can speak with a border official.
So presentation to an official, not territorial crossing.
Right. And then the majority said something really important about the statutory structure. Section 1158 refers to non-citizens physically present in the United States or who arrive in the United States. The court argued that if arrives in only covered people already in U.S. territory, that phrase would just duplicate physically present in and serve no purpose.
That's the surplusage canon. Courts try to give independent meaning to every statutory phrase.
Exactly. The Ninth Circuit said you avoid that redundancy by reading arrives in to cover people at ports of entry, even if they haven't completed territorial crossing yet.
But 15 judges disagreed.
15. Judge Ryan Nelson wrote the main dissent, and 11 additional judges joined Judge Bress's dissent from the denial of rehearing en banc. Even 3 senior judges who couldn't formally vote on en banc rehearing issued a statement saying they agreed with Judge Bress.
What did the dissenters say?
Judge Nelson argued that an alien arrives in the United States only when she crosses the border. He wrote that the majority's reading conflicts with text, history, precedent, and common sense. Judge Bress, writing for 11 judges, called the panel opinion gravely wrong and said it would seriously harm our country's ability to manage its borders.
All right, let's break down what each side actually argues. The government, petitioners here, makes 3 main arguments. First, they say the plain meaning of arrives in the United States requires physical entry into U.S. territory.
Okay, walk me through their textual analysis.
The government pulls out dictionaries. Arrive means to come to the end of a journey to a destination. The preposition in means within the limits or bounds of a place. So, arrives in the United States means coming within the limits or bounds of the United States. Someone standing in Mexico hasn't come within those bounds yet.
That sounds straightforward.
The government says this matches common usage, and they use these great analogies from their brief. Quote, the Greeks did not arrive in Troy while camped outside its walls. A letter does not arrive in the mailbox while still in the postal worker's satchel. And a running back does not arrive in the end zone when stopped at the 1-yard line.
Okay, that running back analogy actually clarifies this perfectly.
Agreed. And the government points out that Congress knows how to refer to non-citizens who draw near without entering. Another section of the immigration statute talks about aliens arriving off the coast of the United States, or near a land border. Near a land border. That's different language than in the United States.
So the government argues that textual variation signals different meanings.
Exactly. And they say the very meaning of drawing a line, like an international border, requires distinguishing between people who get close to the line and people who actually cross it.
What's the government's second argument?
Statutory context. They argue that Section 1225's procedures for inspection, detention, and removal only make sense for non-citizens already in the United States. Like, Section 1225 says immigration officers shall inspect applicants for admission. It requires asylum officer interviews for people expressing fear of persecution. It mandates detention, pending a final determination of credible fear. It orders removal from the United States for inadmissible applicants.
And the government says you can't do any of that to someone in Mexico.
Right. How do immigration officers on one side of the border inspect, interview, detain, and remove people on the other side of the border? The government argues the Ninth Circuit never explained the mechanics, and they point out that the district court's remedy proves the problem. The court ordered the government to facilitate entry into the United States for one plaintiff so she could then get inspection and processing.
So the lower court effectively said you have to let them in to comply with the statute.
Which the government argues proves that arrives in the United States requires territorial entry. Otherwise, the statute creates impossible obligations.
The government's third argument invokes 2 related doctrines, the presumption against extraterritoriality and Supreme Court precedent from a case called Sale versus Haitian Centers Council. The presumption against extraterritoriality says courts presume federal statutes apply only within U.S. territory unless the statute clearly indicates it applies abroad. The government argues arrives in the United States doesn't even plausibly, much less clearly, cover people in Mexico.
And Sale?
Sale involved Haitian refugees in the early 1990s. After a military coup in Haiti, tens of thousands of Haitians fled the country by boat. The United States interdicted many of them at sea, preventing them from reaching American soil and claiming immigration law protections. The Supreme Court upheld those actions in 1993, holding that the relevant statutory provision applied only within United States territory.
And the government argues Sale controls here, They point out that Congress enacted the current language of sections 1158 and 1225 in 1996, 3 years after sale. Congress acted against that precedential backdrop. If Congress wanted to override sale's territorial limitation, they argue, Congress knew how to do so explicitly.
What about the difference between interdicting people at sea versus blocking people at land borders?
The government says that distinction carries no legal weight. Both scenarios involve preventing people from reaching U.S. territory before statutory obligations attach. The medium, water versus land, doesn't change the analysis.
Now let's talk about what the asylum seekers argue. Their first major argument focuses on that surplusage problem the Ninth Circuit identified.
Right. Walk me through their textual analysis.
Sections 1158 and 1225 both refer to non-citizens physically present in the United States, or who arrive in the United States. The asylum seekers argue that, under the government's reading, both phrases cover identical people, anyone already in U.S. territory. That violates the surplusage canon requiring courts to give independent meaning to every statutory phrase.
And how do they give arrives an independent meaning?
They argue arrives in the United States covers people who present themselves at ports of entry, regardless of which side of the borderline they're standing on when immigration officers block them, and they point to the parenthetical in both statutes that says whether or not at a designated port of arrival.
The government responds that parenthetical actually supports their reading.
The asylum seekers disagree. They say the parenthetical shows the statute contemplates people arriving at ports of entry, and they argue that someone presenting themselves to an immigration officer stationed at a port of entry has arrived at that destination even if the officer physically prevents the final step across the borderline.
What about the government's analogies?
The asylum seekers distinguish those. They argue the Troy/mailbox/end zone examples miss the statutory context. Unlike those scenarios, sections 1158 and 1225 explicitly reference designated ports of arrival, official crossing points where immigration officers stationed at the border process arrivals. The statute contemplates interactions at the border itself, not deep within U.S. territory.
The asylum seekers' second major argument focuses on Congress's intent to implement treaty obligations.
Right. This gets into international law. In 1968, the United States ratified something called the 1967 Protocol relating to the status of refugees. That protocol incorporates Article 33 of the 1951 Refugee Convention, which prohibits refoulement.
Okay, I need you to translate that.
Refoulement comes from French. It means returning refugees to territories where they face persecution. The protocol prohibits countries from doing that. And in 1980, Congress passed the Refugee Act specifically to implement these treaty obligations. That act created Section 1158's asylum provisions.
So the asylum seekers argue Congress intended these statutes to prevent refoulement.
Right. And they say the government's interpretation violates that purpose. If immigration officers can block refugees at the borderline before statutory protections attach, officers can effectively return refugees to persecution without any process. That's exactly what the protocol prohibits.
What do they say about sale?
They argue sale doesn't control because that case involved interdiction on the high seas, international waters far from U.S. territory. This case involves people who've reached U.S. ports of entry, official crossing points explicitly contemplated by the statutes.
The asylum seekers' third argument points to government regulations and historical practice.
What regulations?
For over 25 years, government regulations defined arriving alien as an applicant for admission, coming or attempting to come into the United States at a port of entry. The asylum seekers argue that definition supports reading the statute to cover people attempting entry at ports, not just those who completed territorial crossing.
And the government responds?
The government argues you have to read the whole regulatory definition. It limits coverage to an applicant for admission, which the statute defines as someone present in the United States who has not been admitted, or who arrives in the United States. So the regulation incorporates the same territorial requirement.
What about historical practice?
The asylum seekers point out that since 1952, immigration law required inspection of non-citizens seeking to enter the United States. They argue administrative practice for over a century treated presentation at ports of entry as triggering inspection obligations. regardless of precise geographic position at the moment of presentation.
So, what should we watch for at oral arguments?
I think justices will really press both sides on the practical mechanics. If the government's right, what happens to the surplusage problem? If the asylum seekers are right, how do immigration officers actually inspect, detain, and remove people standing in Mexico? I also expect questions about the district court's remedy. The fact that the lower court ordered the government to facilitate entry for one plaintiff seems to support the government's argument that this interpretation effectively requires letting everyone in.
What about the presumption against extraterritoriality?
That could be a major fault line. Some justices might view this as clear extraterritorial application. The statute would regulate conduct in Mexico. Others might view this as domestic application. The statute regulates what U.S. immigration officers do at U.S. ports of entry.
And sale will definitely come up. Watch whether justices view sale as directly controlling or whether they see meaningful distinctions between interdiction at sea and blocking at land borders.
Bottom line time, why does this case matter?
Because it determines whether the executive branch retains traditional authority to manage border surges through policies like metering, or whether statutory mandates require immediate inspection and asylum processing for anyone who reaches a port of entry, regardless of capacity constraints. And that affects real people. Hundreds of thousands of asylum seekers during border surges, whether they can claim statutory protections from Mexican soil or whether they must physically cross into U.S. territory first. If you made it this far, share this episode with one person who thinks Supreme Court cases don't affect real people's lives. Because this case literally determines what happens to asylum seekers standing at the border. That's as real as it gets. That's it for today's episode. Quick reminder, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get nearly daily rundown, and follow on YouTube to see shorts. Just search the High Court Report. Talk to you soon.